Hi, thanks so much for joining our webinar this morning. My name is Jessie Peterson. I'm the Director of Education here at SunRay Construction Solutions. SunRay secures $10 billion annually for GCs, subs, and suppliers. We're a national construction document service. Today's webinar is conducted by the wonderful and incredible Alex Barthet, a Florida construction lien law expert. Today's webinar topic is Chargebacks and Bad Checks Suck. Then do this. So without further ado, I'd like to introduce the fabulous Alex Barthet.
Thanks, Jesse. We all know that chargebacks on credit cards and bad checks really hurt the bottom line. So how do you fix it? How do you minimize that risk? We're going to get into it in great detail today, step-by-step instructions with some sample letters that I'm going to be able to show you that you can use that'll make a difference right away. So let's get into it. If you have any questions during the presentation, you can go ahead and submit it in the GoToWebinar chat box. We will answer all the questions at the end, and please do not include the names of any people or companies in your questions. So let's go over at a high level, what we're going to cover today. We're going to talk about, in Florida, the criminal and civil penalties associated with bad checks. We'll talk about credit card chargeback procedures. We're going to go over some pro tips that we see our best clients use to minimize this risk. And of course, if you have any questions, we will answer them all at the end. So let's start with the basics. What is a check? A check is effectively a promise to pay. It is an IOU. When I write a check to you, it is a document that you can take to the bank, and the bank will give you money from my account. It is a future payment in the sense that cash is present. When I give you cash, you can use it immediately. When I give you a check, you have to deposit it and get the money from my account. So most common bad check designations typically are there are three types of bad check designations. So one, and the most common, is NSF, non-sufficient funds. I cut you a check for $10,000, but I only have $1,000 in my bank account. That check is going to come back as NSF. The second is account not found. I either totally fabricated a check, or I open an account, I got a checkbook, and then I close the account, but I'm still cutting checks against that account. When that check comes back to you, that check is going to be deemed account not found. And the last is a stop payment. I cut you a check for $10,000. I change my mind. I go to my bank or go to my bank portal, and I place a stop payment. Bank, when this check comes back through the routing system, do not honor it. So then it goes back to you as a stop payment. Those are the three most common. Understand that a check can be dishonored usually up to 30 days and some instances beyond 30 days after presentment. This is something everyone needs to keep in mind. The fact that I give you a check and that check is honored within a few days by your bank is not actually an indication that there's money in the account that it came from my account. What it means is that you have enough money in your bank account that if the check is dishonored for any reason, your bank has enough money in your account to pay for the dishonored check. So as an example, I give you a check for $10,000. You have $100,000 in your bank account. Then your bank will show you within a day or two that now you have $110,000 in the account. But it's possible that up to 30 days later, after I present the check to you, I could put a stop payment on it. Now, your bank honored the check, not because they were certain that I was going to honor the check, but that if I dishonored the check, right, if I said, nope, stop payment, you have enough money in the account because you have 100,000 that if they have to return the money, you have enough to cover it. So don't confuse the fact that your bank is letting you access those funds as evidence that that check is in fact good or will not be dishonored. The penalty of passing a bad check in the state of Florida is both a civil and a criminal act. So bad checks of $150 or more in the state of Florida, it's considered a felony. So if I pass you a check for $149, that's a misdemeanor. $151, it's a felony. So let's talk about some important things that you need to keep in mind with respect to your lien rights as a contractor or supplier, so that you understand how to deal with checks. So number one, don't sign a bond or lien release if you are concerned that the check is not good. Because if you do, that lien release is going to be passed up the chain to the GC, to the owner. And if the check is not made good, you will have given a release, an unconditional release, and that unconditional release will release your lien rights. Do not sign a lien satisfaction in exchange for a check if you are concerned that the funds may not clear. So if I record a lien on your property and that lien needs to now be satisfied, and you are willing to, and I'm willing to accept the funds from you to satisfy the lien, I want to get a wire. I do not want to get a check, because if I satisfy the lien and you put a stop payment or the check is NSF, I will have already released the lien. I cannot go back and put the lien on because I have satisfied it. So we tell our clients, if the lien needs to be released, you should only accept a wire as payment for that satisfaction of the lien, because a wire is instantaneous. When a wire is received and you can see it in your bank account, that actually means that the funds are in your account. So how do you deal with the release issue that we talked about if you are accepting a check? And the way you do it is by making that release conditional. How do you do that? You add conditional language to your lien release. We have a stamp that we send out for free. You can go to makemeconditionalstamp.com and we will send it to you. So when you print out the release and you want to make it conditioned on you actually receiving the funds, you stamp it with this stamp, and that stamp and this stamp will add the conditional language to the lien release. Let's talk about some other things you should not do. You should not believe that holding a check, which is effectively just a piece of paper with words on it, it's the same as having money. So we see clients sometimes agree to take a check and hold it to deposit later and believe that somehow that is the same as cash. It is not. You should be very wary of accepting post-dated checks, checks that are dated after the date of today. So for example, if I write a check and today is the July 1st and I date it July 30th, that is a post-dated check. You should not accept post-dated checks. Understand, if you accept a post-dated check, you can no longer seek criminal penalties from the person that gave you that check that turned out not to be good because it was dishonored. You should not also agree to hold a check. So again, I give you a check and I say, hey, look, I just need you to hold it for a week or two. It's dated today, but I say to hold it. If I do that and you agree, then again, you cannot seek criminal penalties against the person who gave you that bad check. When you accept a check, for criminal penalties to apply, you must do the following. If you're accepting the check in person, right, so it's a face-to-face transaction, you need to obtain the following information from the person presenting the check to you and write this on the check. We don't see this happen very often. Occasionally you'll run into someone who actually goes through these steps, and they're doing it because in case the check is dishonored, they can seek criminal penalties. So What do you need to put on the check? What do you need to get from the maker of the check? And what do you need to put on the check? Their full name, their home address and phone number, their place of employment, their gender, their date of birth, their height, and the driver's license number or state identification number. You need to put all of that on the check itself. And if you do that and the check is dishonored, you have set up a very good case, a criminal case against the maker of the check for giving you a bad check. Now, if you accept checks in the mail, right, which is the more common way to accept payment via check, the recipient of the check must have a contract with the maker of the check. The order or request for services for which the check is supposed to pay has to have a signature of the person that is cutting the check. Again, so this is you have to connect the dot, right? So if I have a contract with a homeowner or a contractor, that I need to have a written agreement that is signed by the person that is also signing the check. So if the check is then returned and marked by the bank as NSF or account closed, stop payment is much harder to prove criminally, by the way. Stop payment criminally requires an intent to defraud, which is a much higher burden than just a civil standard of the fact that you owed me money and you didn't pay. But if the check comes back NSF or account closed, then you can send the following notice via certified mail. We typically recommend you send it via certified and regular mail. And here is the language of the letter that you need to send. So in essence, this letter puts them on notice that they have made a payment to you with a check that has been dishonored. And if they do not make good on that check with a small fee to cover the return check charge that you likely suffered, if they don't make good on it, then there may be criminal action associated with the bad check that was passed to you. After the expiration of 15 days, if it's still not paid, then you can report the matter to the local state attorney's office. So how do you find the state attorney's office next to you? You're just going to Google your city and state attorney's office, and it will bring it right up. And then you're going to find their bad check or worthless check division. Every state attorney has a page dedicated to bad checks and worthless checks. You're going to find that page, and then you're going to submit the information to them. Now, for civil penalties to apply, you don't need to do all of that. We can skip over all of that. Remember, criminal penalties mean someone's going to jail. Civil penalties mean that you get to sue someone and you can recover from them monetarily. And there are significant civil penalties for passing a bad check. So the civil penalties apply for NSF, account closed, and stop payments. So the only thing you need to do to seek civil remedies, and I'm going to tell you what the penalty is, it's severe for passing a bad check. All you have to do is mail a letter, and I'm going to show you what that letter looks like, to the maker of the bad check. If you do, and they don't make good on the check within 30 days, you are entitled to the face amount of the check that was dishonored, up to 3 times the amount of the check as treble damages, plus interest, plus legal fees. Okay, so technically up to 4 times the amount of the check, plus interest and legal fees. So it has a significant way of ramping up the total damages against the maker of the bad check. So here's what the letter looks like. Again, it's very similar to the criminal letter in Florida, but the civil letter in Florida puts them on notice and says, if you don't make good on the check within 30 days and you don't pay this little extra fee, and there's a little math formula as you can see in this letter, then they are obligated to pay you those damages plus treble damages if you sue them in court. Again, this is after 30 days. And again, this letter should go, we recommend via regular mail, and it must go certified mail. Now, keep in mind that if someone has passed a bad check to you, they probably don't have the money, or it may be hard for them to come up with the money to pay you. Now, that's what the 30-day window is for, to try to give them an opportunity to make good on it. We usually find that when we sue someone for passing a bad check, we find that they usually default, meaning we get a judgment against them right away, and now we have a judgment for a much larger amount. In many instances, we're able to get paid at least the original check amount, but just know that if someone passed you a bad check, getting a judgment against them for 4 times the amount of that check may result in an uncollectible judgment. So let's talk about credit card chargebacks now. Credit cards are very common these days, so paying with a credit card is, I would say, more commonplace than payment with a check. So first, understand that consumers can submit a complaint to their bank usually between up to 60 to 120 days after the transaction. This rule is dependent on the issuing bank of the credit card. Now, once this complaint is issued, then the issuing bank of the credit card, verifies whether the dispute is valid. It's just a cursory review to see if it's even real. If the bank finds that the consumer is at fault, the process ends there, right? So it would have to be a pretty egregious mistake for the complaint to end there. It usually doesn't. Usually there's enough behind the back charge for the issuing bank to go ahead and keep going. So if the consumer, at that point, the consumer is immediately refunded the money back to their account, and the cardholder's bank initiates a chargeback procedure against the merchant bank. So if you're the merchant, now it's going to start to affect you. The merchant bank, again, it's not the merchant, which is you, but the merchant bank now verifies the request that there is a chargeback, and they start their own investigation. Now you are notified that a chargeback is in process, and one of 2 things is going to happen. One, the chargeback is deemed invalid at that point, and the merchant bank will tell the other bank that you win. So this usually happens because some paperwork issue is so clear that the consumer who started the chargeback was clearly wrong, and the merchant bank, your bank, can dispose of the chargeback right away. This is rare. It usually doesn't happen this quickly. The more common issue is that it's deemed valid on its face, and the merchant bank, your bank, is going to now ask you to submit documentation to support your position on why the dispute is invalid. So if you provide sufficient proof, the chargeback will be stricken from your record, and the issuing bank will remove the funds from the cardholder's account. Once again, don't forget, they took it from the account, then they put it back when the chargeback started. And now if it's determined that it is, in fact, that you were correct, then you get to get the money back. Now, if not, the funds remain, the funds are removed from your account, right? So if the merchant bank, your bank, does not agree that you are right, they're going to take the money from your account. Plus, they're going to charge any additional fees charged to the merchant, such as their investigative fees. Typically, it's a flat fee for having to go through the process. So they're going to withdraw that from your account, and you will have lost the chargeback. Again, that's why documentation is critical. You must enforce the policies by each of the payment processing networks in order to properly prevail on a chargeback dispute. Here's what they are. Number 1, you have to obtain proper verification from your customer that they are who they say they are. 2, you need to make sure that they signed the receipt and that the name of your business is legible on their bill or the receipt. You have to verify that the card is not expired. Number 4, you have to verify that the cardholder is actually who he or she says they are, by both verifying the signature on the back of the card and checking identification. If you don't do these things and have evidence that you do them, the chances of prevailing on a chargeback is very low. You have to be able to document that all of these things took place. You also have to adhere to all of the current security standards like chip readers. You have to capture your customer's signature digitally and compare that signature to the one on the back of the card. You cannot accept credit cards where there is no signature on the back of the card. Again, look, I'm a consumer. I use my credit card all the time. How often is it someone actually checking that I am the one that is the proper holder of the card? No one asked me to look at the signature on the back of my credit card when I touch my credit card on the chip reader. So keep that in mind, that if you don't do these things, if a chargeback occurs, the likelihood of prevailing goes way down. You need to also have strong terms and conditions of sale that the customer must sign. Those terms and conditions of your sale, whether it's your contract, your terms and conditions, purchase order, anything, those are what is really going to save you in the chargeback dispute. So for example, if the customer complains about an issue with your product because it's late, because it's not the right color, it's not the right shape, it's defective somehow, and you have terms and conditions that disclaim those issues, you can use that as evidence to support the fact that, no, I never promised that it was going to be delivered on June 5th. Look at my terms and conditions. I never promised that it was going to be this exact color. Look at my terms and conditions. So having proper terms and conditions that disclaim the things that people may complain about will go a long way at allowing you to prevail on a credit card chargeback. If there's any doubt about the ability of someone to pay either via check or credit card, you want to get a wire transfer. Wire transfers are immediate. Next, you always want to protect your lien and bond rights. We talked about the idea of using the make me conditional stamp to make lien releases conditioned on actually receiving payment. And you don't want to take a credit card or a check that you are concerned may be dishonored when you give a release, unless of course you make it conditional, and especially not when you satisfy a lien. You only want to accept wires then. And then the question is, well, if I got a bad check or I lost my chargeback with the credit card, what do I do? Just know you can always still sue your customer, whoever gave you the bad check. We talked about the penalties that are there. And if you lost the back charge with your credit card merchant provider, you can go ahead and sue the customer for breach of contract, unjust enrichment, account stated. There are a lot of other legal theories. So it's more, it'll take more time, it'll cost more money because you have to go through the legal system, but don't think that just because you lost the chargeback with the credit card vendor, that's it, you're stuck, you've lost forever. You can still pursue those legal claims in court, and you probably will win because the level of scrutiny that the credit card merchant is going to give to allow the other side to win is much lower than what will be in court. If you have the proper documentation, the customer got the materials or equipment or services, you probably will win in court, even if you lost in the chargeback. So with that, if you have any questions, I'd love to hear them.
Well, thank you, Alex. As always, you really are very, very insightful, and you break it down in such a great way. So thank you. We do have a question that has come through. It says, if I'm paid with a credit card, should I only issue a conditional release until 120 days have passed before I issue my customer the final release?
I mean, that would be the gold standard. My guess is they won't like that, but if you want it to be absolutely positively certain that no one can do a chargeback, that's what you would have to do. I would tell you that risk is likely very small. I don't see that as common practice, but yes, you could do that if you were concerned. Typically what we see our clients do is they give everyone the benefit of the doubt until there's a reason to have a doubt, and then they create heightened standards for those people.
Understood. Thank you. Another question that came through, and I think you just touched on this just before. It says, if you do accept a check and then satisfy the lien, but the check bounces, I understand the lien rights are gone, but could I still have a lawsuit against the client or property owner?
The answer is absolutely. So if someone passes you a bad check, you've satisfied the lien, thinking the check was going to be made good, only to find out it wasn't, you can then send that letter that I showed you what it is, wait 30 days to see if they make good on the check. If they don't, then you can sue them for the bad check. You can sue them for breach of contract. You can sue them for unjust enrichment. You can sue them for, again, many legal theories, even though you can't proceed with your lien because you actually already satisfied it.
Okay, wonderful. Thank you so much for clarifying that for them. That does seem to be the only questions that were posed. If there's any other questions that weren't addressed, please feel free to reach out and we'll be sure to answer those for you. Here are some of SunRay's resources to help you stay organized, know your deadlines, and secure your lien rights. So go ahead and scan that QR code to access these incredible resources. Next slide, if you don't mind. All right, our next webinar with Alex is going to be Thursday, November 20th. That's how to get the bonding company to pay me. And then on December 11th, oh shit, I blew my lien deadline, now what? Sign up for free at sunraynotice.com/education. We'd love to see you guys there. I'm sure they're going to be very, very great. Also, if you are in the Miami area, Alex is going to be presenting alongside with Ariella for a live seminar on October 16th for a lien waiver and release masterclass. It's going to be really, really great. It's going to dig in deep. So if you are interested, register at sunraynotice.com/seminar. And then the next slide. All right, if you don't mind, take a quick moment to give us a review on Google. It really does help us get some feedback and kind of know how we can improve and get the content that you're looking for out there. And then the next slide, please. All right, and with that, that is all we have for you guys today. Thank you so much for everyone that attended. We hope to see you guys at our next webinar. Again, Alex, you really are incredible. Thank you so much. I hope you all have a beautiful and wonderful sunny day. Thanks, everyone.